that, ladies and gentlemen, we kick off our knowledge series, which is Legal Lens on Redevelopment. And please put your hands together and let's welcome on the stage Advocate Ameet Mehta, Managing Director of Solicis Lex Advisory and the member of Academic Council at Government National Law University, India. Please put your hands together for Advocate Ameet Mehta. May I request you to kindly join us here, sir. Firstly, a very good afternoon to you. Before we officially let you take on the stage, I just wish to ask you a question. How does it feel? I think I've always said this, that redevelopment is not about development. It's an emotion. You know, for generations, people have lived in this beautiful city, and now we're seeing it completely transform. What is your feelings behind it?
I think now the trend has changed, and we are getting not just bigger house and better house, but we are getting more quality houses and more trendy houses. And now is the time when we should encash. You know, if you're on a Mahada land, you get a lot of FSI. And now is the time Mumbai can encash. Half of the Mumbai is almost in redevelopment right now. Every third building is going for redevelopment. And I think that's a great event today where MCHI Credai has kept this for the mass at large. And I think people will benefit out of this.
Absolutely correctly said. And I think another dignitary of ours on stage did say that redevelopment is not the greed of the hour, it's the need of the hour. And half of Mumbai is going under redevelopment at the moment, and the other half will continue to go for redevelopment. I think when it comes to the legalities, you're the right person to answer their questions. So over to you for this knowledge series. Thank you. Would you like to use the hand mic or would you like to use the podium? Perfect. Ladies and gentlemen, once again, can we please have a big round of applause for Advocate Ameet Mehta? Thank you.
Good afternoon, everyone. I know it's a very heavy session after lunch. It's a very difficult session. But I'll make it more informative. I'll make it more knowledgeable. And we'll have a good interactive session also, where you'll get all the answers to the questions that you have in mind. So let me just give you a little bit brief background about redevelopment in Mumbai. The broader aspect right now, that you'll be looking at most of the places across geographies in Mumbai which are going for redevelopment right now. And especially the suburbs. Most of the buildings have become more than 30, 40 years old. And the trend now continues now in South Mumbai. South Mumbai has more challenges than the North Mumbai. But overall, you would have seen the trend has changed from a builder perspective to a construction house perspective. Now let me tell you the differentiation in this. Earlier we had a lot of builders and it was not a very proper industry. Now most of the developers have become a listed company. They are also now being very systematic in nature. And above all, there is a lot of focus by the government in this industry now. The top 20 developers, I have seen now, most of them are listed companies, maybe bearing few here and there. And the entire focus from a redevelopment has now shifted to a quality redevelopment. In the last, especially about 20-25 years, now let me give you the pre-RERA and the post-RERA period. Pre-RERA period, that is called the MOFA period, that was prior to 2014. You would have seen the lots of societies. The committees were cheated by, you can say, a low-end developers and builders. In 2009, you would have seen that the GR came, the 17NA procedure came, and a little bit systematic procedure started in Mumbai. But that was not the only thing. What really changed the sphere is that the government put special departments focusing on this also. The 17NA procedure was the start of it. So an IS officer was deputed, he gave a shape to this, and that's how the GR came. And then the GR was also amended about few years before also. 17NA, you would have seen one of the judgments in High Court that it is not mandatory. This question would have been there in many people's mind, but let me answer some of them right away. So, even though it's not mandatory, still it is very systematic, especially for Mahada plots. It's helpful to all of us. One of the reasons of 79 is also to find out today who may be a prospective dissenting member. Earlier it was a trend of 70-30, now it is 51-49. Even though 51% give a consent, the 49% becomes the minority. So the start of that would start with the resolution by a general body in a society where majority of them vote for, yes, we want to go for redevelopment. Then they appoint a PMC. PMC is project management consultant. That's a combination of an architect, an engineer, and a company which will also facilitate the quality part of it, the bar chart, the tracking of the entire project. Once the PMC is appointed, either the PMC or the law firm, either of them are first appointed. If the PMC is first appointed, he would work out on the feasibility report. If the lawyer is first appointed, he would start with the PMC agreement. But it doesn't matter who is first. And then the PMC and the lawyer, they are actually two pillars of redevelopment. So if a society has to continue with redevelopment at a good pace, you need to have a good PMC and a good law firm. And of course, the good developer also, because this would facilitate a good developer also. Most of the developers in Mumbai, you can say about 50%, have now become very quality conscious, have become very systematic, and are doing things in a very systematic way as far as execution is concerned. Once the PMC and lawyer are appointed, they would make a draft tender. So the draft tender is first made that by the PMC, and the lawyer vets the draft tender. He would put his legal points, he would put his commercial points, he would give the financial report, he would give the legal cases going on. Now, if you ask me as a lawyer, what would I focus on a good developer? The first three parameters I would consider as very important. First is the litigation history of a developer. I would not like to appoint a developer who has so many litigations going on. A litigation doesn't mean that litigation within the developer's family or within the directors or within the partners. A litigation for me in redevelopment would mean either developer has filed a case on the society or the society has filed a case on the developer. This is a very important parameter as far as I am concerned. The second important parameter is the completed projects in the last couple of years. So I would ideally look at least the last 2 or 3 OC copies, the occupation certificate copies, for me to rely, yes, he has completed projects, on time, and also has delivered good quality product. That's the second parameter I would look at. The third and most important parameter which I would again look at is the balance sheet and profit and loss statement. Now, if my project is about 1,000 crores, I would not give it to a developer who is having a turnover of 5 or 10 crore rupees. I would look at someone who has 200, 300, 500 crores. So there has to be some balance. This balance is required for continuous flow of payments to the project. So if supposedly I have a 1,000 crore project, at least I would look at a solvency of 200 crores because that is the cash flow I would require in the project. These are 3 basic parameters which I would look at first. Now I would also look at some of the parameters which I am going to place in the tender apart from these 3. So if the size of the project is quite big, I'd also look at something where the developer who I am going to appoint would have done a large size project. So if a project is of say 10,000 square meter, I would at least like my developer would have done a 5,000, 6,000, 7,000 square meter worth of size of the project. I would not look at someone who has not done in a 1,000 meter project. Another parameter which I would look at is the manpower available with them. We need to go and check now because many companies are listed. It's very easy to identify. We go online and we can find all the reports. But if the company is not listed, at least we would look at some parameters like these, which shape up that this is the type of developer I am looking at. Once the tender is floated in the market, you would ideally get about 5 or 10 responses. So let's say you are getting 10 responses. Now these 10 responses are from a situation where I have already screened the developer who is not even going to collect my tender if it doesn't fit that parameter. So the first screening happens at the stage where I have set some parameters. If you fit this parameter, then you can pick my tender. So he picks my tender. 10 people have come with their, who have collected my tender. Then there will be a pre-bid meeting. So pre-bid meeting is a period where the developer has collected a tender but is not yet submitted the tender. So example, On 1st of May, my developer collects a tender from me. After collecting the tender, I may keep a pre-bid meeting in 30 days from the time. In the pre-bid meeting, he would have certain queries from the society. He may have queries related to conveyance, he may have related to titles of individual flats. Lots of things may come in mind of the developer also. So the developer would go into the pre-bid meeting, get all the answers, and then they are giving about 15 or 30 days time to again submit back the tenders. Once the developer submit back the tenders, the vetting of the offers start. So there are offers first made by the PMC. They would make a comparative chart. Once the chart is made, they would look at all the parameters, previous projects done, what is the corpus, what is the rent, what is the extra area, what is the brokerage, what is the shifting charges, and what are the other FSI benefits he is passing on to the society. Generally, the trend is that you may go for a highest offer. Let me caution you here. The highest is not necessarily the best offer, and the lowest is not necessarily the worst offer. You have to see a combination. Combination means the brand who is offering it versus the offer what he is giving to us. Maybe a bigger brand may be slightly conservative. A smaller brand would bid more aggressively to get the contract. But we should be very careful while evaluating this. The reason, maybe a smaller brand or a person who is a startup developer, he may give a more better offer, but he may not have that capacity to do it. So you should look at their profit and loss and the balance sheet also, and also ensure that you have a solvency certificate, which normally we prefer from a nationalized bank. This solvency certificate is given by the bank saying that the developer has X crore available with him for the project. Once the comparative is made by the PMC, then we do the legal due diligence. Generally, the legal due diligence focuses only on litigations which are against the society, or the developer has filed, or the society has filed. The reason I am saying you, if a developer who is not a very of good repute, he would be more interested in litigation. Litigation का मतलब है कि he enters the society, litigates, and he stays there. I think most of you would have experienced it, where a developer has come in and is litigating with the society. A litigation could be genuine litigation also, but we do have a track history of those developers. Even if the litigation is more, it doesn't mean that he is not a good developer. We may go into the details of those litigation also. That's the due diligence we are supposed to do. So if I am tracking 10 developers and I'm making a comparative of 10 developers, I would also see their litigation history. So I would make 10 different reports of those developers. This is very important for all of us. Once we come with the evaluation, then the voting starts. The voting will be based on the majority. And once the voting is done, you come from maybe 10 to 5, 5 to 2, and 2 to 1 you may come. Once the serial number is shortlisted, normally we give a letter which is called most preferred developer. We don't give a letter of intent at this stage. We give a most preferred developer. And then if the society is going for a 79A procedure, once that is done, then we give a letter of intent. The difference is like this, that a most preferred developer is, there is a mock voting happening in the society. The members select a developer who is the most preferred by them. That's why we called it most preferred developer. But the letter of intent is a confirmation. Confirmation means a 79A procedure executed. The developer is selected in the presence of the deputy registrar's representative. And then the letter of intent is given. When the letter of intent is given, we may either go for a development agreement or a MOU. Now I'll tell you what is the difference between both of them. An MOU may be certain obligations which are required to be fulfilled, either by the society or the developer in a period of maybe 2 to 3 months or 5 months or 6 months. So supposedly there are some corrections to be done in the PR card in the name, or some conveyance related documents to be done, some title related documents have to be done, or some road setback issue is there. So these things are done by other parties who are supposed to do in that period. But if the title is very clear, there is no issue, then we can directly go for development agreement. That is called a DA. The DA is the most important document. Even though it takes little time to execute, please do take a lot of time to execute a development agreement. Ideally, we would take about 45 to 60 days time, but there are some projects where we are doing the DA for the last 6 or 8 months because there are too many to's and fro, questions and answers going on with the developer, with the members across the table. Once the DA is executed and registered, simultaneously we also register a power of attorney. The power of attorney is called a specific power of attorney, which has only rights pertaining to redevelopment only. So there is nothing to worry. It is called irrevocable power of attorney, but it is only related to redevelopment only. Apart from the development agreement power of attorney, we also execute a bank guarantee. Now, prior to 2014, that's the implementation in Maharashtra happened in May 2017, the RERA got implemented. But prior to that, bank guarantee played a very important role. Today it is relevant, but there are options available. Because the consideration what the developer is receiving today, 70% is now put in the escrow account. So the relevance of bank guarantee has come down. So what are the other security available for me, apart from bank guarantee? Earlier, the developer had to pay 10% for getting a 100% bank guarantee. Then they had to pay 20% to the bank to get the 100% bank guarantee. Then it became 50% to get that 100% bank guarantee from the bank. And now it is 100% deposit to the bank and then getting that 100% bank guarantee. So the cost is increasing. So what has happened? There are three other options we have taken out of security. So one is the bank guarantee. I may have a bank guarantee up to 10%, 15%, 20%. So in 79A procedure, it is written you can have a bank guarantee up to 20%. So don't misunderstand that you have to get 20%. It is up to 20% of the bank guarantee. Apart from this security, there are three other securities available. If at all the society says, okay, let's waive off the bank guarantee, but we can have some other security. So first security is loading of the FSR and TDR in the name of the society. There's a second option available apart from the bank guarantee. Example, if the developer has to load an FSI or a TDR up to 50 crores, that amount is paid in the name of the society and then he gets the receipt from the particular department. There's a second security we can take if we are waiving off the bank guarantee. The third security, if we want to waive off both of these, we can have another security, and that is called lien of the flats. Now, lien of the flats, I am divided into two parts. So there option one, which is my third option of the guarantee or you can say security. I take the lien of flats in a project which is already completed somewhere outside, where OC is received, and then I'll take lien of those flats where the project is completed and the OC is received and the society is the equivalent amount of worth of flats with the society. That is the third option available. Now that also many times the developer says, no, I am not interested in giving lien of the flats which are completed. I'll give lien of the flats in the same building where I am going to construct your building. That means that security is in air. Let's be very realistic. So example, my 25 floors are going to be constructed and he is going to give me lien of 22nd floor. Where is the 22nd floor? How will you execute it? So what we do now, we take the lien of the 22nd floor or whatever that floor is in air. We also take a undated check as a security of an equivalent amount simultaneously. So I am having double security now because I don't have a bank guarantee. I don't have FS or TDL loaded in my name. I don't have a lien of a flat where OC is already received. So what I am doing now, I am taking lien of a flat which is already in the air, which I don't know how I am going to execute. But along with that, I am also taking the undated check of equivalent amount. So example, if I am getting the flats which are worth 20 crores, I'll also take a 20 crore worth of check with me, undated, so I can deposit any given point of time, but it is with a rider. The rider is, there has to be some default, and I would sign a escrow agreement with him, with the developer, and then we write that we will be giving you a time to correct the violations for 2 months, 3 months, and then we'll deposit the security check. So understand there are 4 types of security we execute. So bank guarantee is not necessarily the best security today. That is one of the good options. But apart from that, we can use these 3 options also. So bank guarantee is one of the main clauses in my development agreement. Once the development agreement is executed, these points are covered. Let me also highlight 2 or 3 more important points in development agreement. So one important clause in development agreement is the penalty. He is supposed to say complete the project in 42 months. Then instead of 42, he may drag on till 48 months. Technically, he is allowed to take the project till 60 months as per the RERA. So up to 60 months, he is allowed to take the project. Even though my contract is saying 48 months, he may be allowed to take till 60 months. But in case of a conflict of a clause between my development agreement, which is registered, and the RERA clause, the development agreement clause would survive. If my clause is saying 48 months, but the RERA is allowing 60 months, still I am able to file a case in specific performance that you are supposed to complete the project in 48 months. These days you are aware that some notification comes and suddenly the project stops or it is slow. Like in Juhu area, you would have seen the radar issue is going on. People got permissions for 12 floors, then they were supposed to make 16 floors, and then you know what is the situation today. So that is one of the important clauses, that is a penalty. So if the project is delayed beyond my timeline which is agreed with him, I may put some penalty in there, which is a barrier. It's a barrier for them to not delay the project. Then another important point is compensation. Now, penalties I'm putting, but I need to be compensated also. Suppose I am agreeing, okay, you were supposed to complete the project in 42 months or 48 months, but you are dragging the project for 60 months. So what about those balance 12 months? Are you going to compensate me? So we take a higher amount of rent, we take extra brokerage. So these are some of the compensation we take if the project goes beyond the timelines which is agreed in the development agreement. Apart from that, there is a tracking of the bar chart. So in the development agreement, we are writing, say, example, 42 months. So you keep tracking the bar chart continuously. You don't wake up on the 42 month saying that my project is delayed in the 43rd month. You start tracking from month 2, month 3 also, that you know the project is delayed. Every month there is a tracking going on, and every month the PMC, the lawyer and the committee keeps on meeting, tracking if the project is on time or no. Let me caution you one more thing. Once you are vacating the building, you all are scattered at various places, but you should ensure that every quarter you meet frequently. This is very important for you to come together and keep a track of the project. This also shows you are aware of your project. You are keeping an eye on your project if it's delayed. So this should happen from your side also. Once the DA is done, we have registered a development agreement, all the flat numbers are written, and then you submit that to the developer. He has one original copy, one copy you keep, one copy he keeps. And based on the development agreement and power of attorney, he would go to the department. If it's a MHADA project, he would go to MHADA department, building and proposal department. If it's a BMC, he would go to the BMC, building proposal department. He would try to get the IOD. An ideal time of getting the IOD is about 3 to 4 months time, average. Once the IOD is received, he would give a notice to the society that you please vacate the building. You may vacate the building in 30 or 45 days time. That's the average time given to a society. Now, before you vacate, you need to take care of a couple of things. This is very, very important. Many of us do not remember this, but we need to keep a track because it delays the project otherwise. So if you are about to vacate the building, you need to execute a PAAA, which is called Permanent Alternate Accommodation Agreement, which is your individual identity. Now I cannot or I should not vacate the flat till I get that document in hand, that too registered. So I will sign, my committee will sign, it's a tri-party agreement, and the developer will sign. It's called a PAAA. Once the PAAA is executed, you hand it over to the developer. He takes your keys also. At the same time, he will give you corpus on rent. Now the corpus and rent, which is actually called corpus and rent, but is renamed now. It is renamed why? Because there was an income tax case which happened where some tax was supposed to be paid by members. They became liable as per income tax, but ultimately the members won the case, and in the judgment it was written that please rename the word corpus and rent. So the corpus is called as hardship compensation and the rent is called as displacement compensation. You need to use these words so you're not liable to pay any tax on that. So once you hand over the PAAA to the developer along with the key, he will give you the corpus and the rent, but he will not give you to the member directly. He will give you to the managing committee. Why? Because the managing committee has to settle the maintenance issue, the property tax issue, the sinking and repair fund issue with individual members. We have to settle the account with everyone. There could be some defaulters. I cannot give him the corpus and till the time he settles the amount. He cannot even vacate till the time he settles the amount. There is a property tax, he is defaulting, I have to recover that. There is a sinking and repair fund which I have to make and nullify it and make it zero. Why you have to make it zero? See, the sinking and repair fund is technically required for a major repair in the building. Now the building is getting demolished. What will you do with that amount? So you settle the amount with every member. You allow the society to give away, at least on the paper, the sinking and repair fund and make it zero. Because now, supposedly you are 100 members in society today, another 100 are going to join. So they should not claim that this amount, we are also supposed to get this amount. So you technically make it zero for the original members and start it afresh. So these accounts are very settled. And one more important thing before vacating is mortgage of the flats, individual flats. Now many of us forget this. We delayed a project only because the bank did not allow us to vacate those 2 flats because that was the security of the bank. Example, I am a 100 member society. 2 flats are mortgage. 98 are not mortgage. 2 are mortgage. But I forgot to talk to the bank. You cannot demolish those flats because that is the security of the bank. So in one of the societies in Chembur, an FIR was lodged because they did not know that it was mortgage to the bank and they demolished the building. The bank automatically lodged the FIR. The security of the bank is demolished. So please ensure that you, before you vacate, you take an undertaking from the members. If they are mortgage, they have to declare it. If they are not mortgage, then also they have to declare it. In both situations, they have to declare to you. So that records has to be there with you. So before demolishing, ensure that none of the flats are mortgage. If they are mortgage, talk to the bank and replace the original agreement with the PAAA. So the bank is secured with their new agreement. Example, my old flat is 201. My new flat may be 501. I need to replace that agreement. Once the vacating is done, now everything is clear, the vacating is done. So members vacate the building and the project starts. Earlier, the RERA number used to come after the IOD. Now the RERA number is coming after the CC. So let me talk about the timelines now. So supposedly on day 1, I am registering the DA. On say about 100 days after that, I get the IOD. After those 100 days, maybe in about 45 days, I vacate the building. After vacating the building, the plinth, the CC, and then the RERA number comes, which is another, you can say 4 to 6 months time. So technically, it's almost a year till your project gets a RERA number. Why is RERA number important? Because the developer is able to encash it, sell the property, sell the sale component of the project. Now, are the original members covered under RERA? The answer is no. Yeah. The answer is no. Because RERA is applicable only if there is a consideration being exchanged. So note that RERA doesn't cover the original members. However, the members or the original members are at the lower floors and the sale component is normally on the higher floor. So automatically you get covered. Otherwise, if you're buying extra area, you are anyway going to get covered. So this is the life cycle, and then the project starts, and then the OC comes maybe after 36 or 48 months, and then you are handed over. It is handed over to a PMC, that is called a Provisional Managing Committee, not the Project Management Committee, the PMC, the Provisional Managing Committee, that the PMC takes over for 12 months time, and then the elections come, and then the new members take over. So I think this is the entire life cycle of an entire development. I would like to take the opportunity to take some questions so that we can answer those questions also. Thank you very much.
I think we can just open the floor for Q&As. Yeah, just 1 second.
I would like to know the name of the society where this dispute of mortgage flats have taken place in Chembur.
The dispute of?
Mortgage flats in Chembur.
Yeah, I'll give you the name of, I will not declare in public, I'll give you the name, yeah.
Please.
Yeah.
Because I'll have to,
Yeah.
What do you think about redeveloping with ongoing rent control eviction suits in a property?
Are you talking about eviction because he is a dissenting member?
Well, a landlord has filed eviction suits against his rent control tenants. What do you
No.
think about redeveloping that?
No,
property?
we are talking about mostly cooperative societies only. But as
Okay.
far as the landlord is concerned, yeah, Mr. Dominic would like to answer that.
Whether it's a cess building or non-cess building. Cess. So now MADA this morning has come out with an act where the tenants can develop the building if the landlord is not consenting, and the landlord will be managed by MADA. So you don't have to worry anymore. So under 79B, the tenants can go to MADA and get the approval, and the area what has to be given to the landlord will be given by MADA. So you don't have to worry whether he's taking you to court or not. You have to find a builder and move on.
Yeah, but there is a catch here. So we had a recent case of a building called Chandralok Society in Goregaon, where we won the case, and that court allowed the tenants to do the redevelopment. But the catch was like this, that they could only construct the area on which they are staying today. So there is no sale component. If there is no sale component, how would the developer make out the money? So
No.
the project again got stalled.
But his is cess building in city side, that's the difference. So with the new thing.
Yeah.
Yeah, so if the building is dilapidated, you can file, but that is a matter which you can go, you all can be united and go to MADA and get him getting his share of the redevelopment. So eviction should be moved off because you are already moving out and redeveloping the building.
So is the eviction related to rent, or maybe some changes, structural changes? Huh. Yeah.
One point, sir.
Uh,
So this way,
One more question. This security, what we are taking, this is for the value of the flat before the redevelopment or after the redevelopment?
No, the valuation what you arrive at. Example, if your bank guarantee would have been also 15 crores. Example, I'm saying.
Today my flat is worth 1 CR. After redevelopment, it becomes 3 CR.
Yes.
So 20% of
The new valuation, not the old valuation is going to be demolished, na? So you'll take out the new valuation only.
normally builders are
Because the
making-
example is on 22nd floor. So I'm going to take the building which is going to come up.
So that is a valid point.
Valuation of the new flat.
Thank you so
Yes.
so in case of, sir, this side, actually,
Yeah.
in case of a default by a builder, what is the liabilities on the managing committee? And can you briefly tell out regarding 33(1)(3)(7) and all that briefly? The
You're talking in
situation
terms
where-
of scheme only?
Yeah, scheme also. And in case of default by the developer, what is the this?
See, the PMC would play a very important role
Right.
as far as the feasibility is concerned. An ordinary person would not be able to make out a proper feasibility report. And they would only recommend under which scheme you should go. But you would normally know if it is a MADA plot, what schemes are available, it's a freehold, what schemes are, or it's a collector and what schemes are available. So we need to study it well before you, along with your PMC, to arrive at a solution on that.
Good
Excuse
afternoon,
me. Sir,
Yeah, you have option not to appoint a PMC, but it's recommended to have a PMC so that at least you can get some idea about what you're going to or supposed to get it. Yeah, they can. Yes, they can. But check in what sense? No, but see, no, that's a very open question about manipulation. But ideally, a PMC would give a broad idea. We necessarily not be relying fully on that, but at least you get 90% of the idea on that.
Good afternoon, sir.
Hi.
Sir, you must be one of the lawyers. So, like lawyers like you, how much do they charge for, negotiating between the society and the redevelopment and getting the process through, like, just
So
to
she's
get
asking
an
my
idea?
fees. So the answer is I am not doing it free of cost.
Yes, sir. Okay. So one more thing, a very important thing. Like we are a cluster of 14 buildings in New MIG, Bandra East. But the thing is, it's a MADA land, and the garden that was supposed to be given to us was taken over by the slums in Behrampada. So like we are having a little problem in getting the FSI because it was taken away, and there is continuous encroachment by these people
Right.
on our approach road, and all the stuff.
So are there
around.
3 government buildings also in that 14 buildings?
Exactly, sir. ONGC, Revenue and Customs.
So I am the lawyer there. I'll talk to you separately on that.
Yes, sir. A very thanks to you.
sir, hi. We belong from a housing society in D Ward, South Bombay. So the situation of our society is such that we have a share certificate. Everyone has share certificate, but the land belongs to a landlord. Right now, currently, the landlord is not traceable. So the society members are willing to go for redevelopment, But in such scenarios, how can we move forward where the landlord is not traceable?
Why don't you go for deemed conveyance?
There is a lease. There is a lease.
You will get
99
you will
years
get assigned.
lease.
You will get assignment. It's called conveyance with leasehold rights. So there is a society called Inlac Society in Yari Road. So we have got the conveyance for them. It is called assignment with leasehold rights. You still get the conveyance.
Okay. With the lease, we'll
Yes,
get the
but you
conveyance.
need to be a cooperative society. You need to be a cooperative society.
Good up.
So we can go for redevelopment
Yes,
with
you
our
can.
current status.
Yes, you can.
Okay, thank you.
After taking all the question also to redevelop, can there be a provision that if the redevelopment is stalled for some reason, then the redevelopment committee has the right to take over the building and appoint someone else?
Yeah, are you talking about the managing committee and redevelopment RDC separately?
Yeah, they are separate.
No, see, ideally, MC would be above the RDC.
Okay.
That's a normal procedure. Unless the general body has given them extraordinary rights, that the MC cannot sign, only RDC can sign.
Okay.
Then it's a different issue. Otherwise, the MC is supreme in every society.
So we can have a provision that in case of it is stalled, the managing committee will have the right to take over.
Yes.
Hello. I have Mada Society is a small area, somewhere around 1400 square meter plot. Can I do the redevelopment? 1400 square meter plot.
Yes, you can. What is stopping you?
Because single building we are trying to that. And another building is in my side, is also same area. How much area for cluster? Two buildings
For cluster of Mahada, you require 4,000 square meter. For a freehold, is 6,000.
is for Chandivli.
Yeah, for Mahada, it is 4,000. For cluster, it is 6,000. In freehold, is 6,000 square meter.
Both building area total around 300 square meter. Can it
300 or
possible?
3,000?
3000 square meter.
Yeah, but that cannot be counted as a cluster.
I'll get more FSA than cluster. Don't worry in Mada. It depends on what your area is and what is the other proportioned area in the layout which will be allocated to you. So you'll get much more area. Today we as developers cannot consume FSA of Mada. That is the potential of Mada plots.
Sir, I want to know the exact proper words to use in development agreement to avoid the capital gain when the developer not able to give the possession to the society within a time within timeline. I'm asking this question because some so-called experts says just making a simple wording on a development agreement
So
does not protect the
Yeah, it
tax
does.
liability.
So there is nothing like capital gains on original members unless there are certain parameters in their own files, in income tax files. So there are no capital gains on this. And whatever cost is there, as far as the free area which I am getting, I am eligible for, all the costs are normally paid by the developer only, except the GST issue which is going at the Supreme Court. Other than that,
No
so you are mostly covered in all the cost,
no need to
but not in the personal file of capital gains.
okay, no need to write in development agreement for the particular
No, that is covered in the development. All the points are covered in the development agreement. If you want, I can share you a format of a development if you want to. Yeah.
Sir, 1 minute.
Format, yes.
Sir, in case of the development under 3311, where there is no question of loading FSI on the name of society because he is getting the free FSI because of the slum development, what is the provision for raising the security?
No, all this security what we are given, all are covered in all such schemes, in addition with any scheme, and that's why the options of the security are there. So in any one of the schemes or any of the schemes, these four will be applicable.
And second question is, if one of our member is having the flat is in the name of the deceased person and the family is not able to settle, the person is occupying is one of the son. But now there is a dispute and the other person has given letter that it should not be transferred to his name. That is, we are all taking care. But how to deal with that flat in case
See,
of
example, if there is a deceased person and there are 3 legal heirs,
yes,
okay, and one of them is occupying,
occupy, yeah.
you take the flat back from the occupier
Okay.
and you give it back to the occupier. But at the time of giving them back, you give it to all the 3 legal heirs, the keys.
Okay.
You cannot give it to only one person.
But we can give rent to the occupier.
No, you have to divide by 3 only.
Okay.
You have to divide by 3. Your title is not clear. How can you give to one person?
That is the question.
Yes.
Okay. Thank you.
Hello.
Hello.
Question in 3311, the clubbing is done in the society's name. So you are double protected there. So even the free sale of the developer is the clubbing is done in the society's name, not in the developer's name. No, he has to do it in the clubbing because the CTS number belongs to the society. The right is the society. So society is far more protected in that particular thing when 3011 clubbing is done.
हेलो
हेलो
सर मेरा आपसे
Where?
दो तीन
Yeah.
क्वेश्चन है
हाँ.
एक आपने बोला था कि जो सोसाइटी है वो जिसमें रेरा में कवर नहीं होगा जो एग्जिस्टिंग मेंबर है वो कैसे कवर हो सकते हैं?
स्पेसिफिक परफॉर्मेंस है, आर्बिट्रेशन है अंडर हाई कोर्ट.
ओके,
यस,
मतलब हम लोग रेरा में कवर नहीं होंगे जो एग्जिस्टिंग मेंबर है, अगर एक्स्ट्रा एरिया खरीदेंगे तो कवर
तो कवर होते हैं, ऑटोमेटिकली कवर होते हैं.
और एक आपने बोला था कि रिप्लेसमेंट ऑफ एग्रीमेंट जो बैंक में लीन है तो वो काम सोसाइटी का है या मेंबर का है?
The prime responsibility of declaring it is of the member, but the doing that job of replacing is that of the society with the banks. आप देखोगे कि बैंक्स लेटर आपको बहुत बार देती है कि भाई इन केस कुछ भी इसका ट्रांजेक्शन हमको बता देना, या आपको चेयरमैन सेक्रेटरी को मिलता ही लेटर है. So responsibility is of the managing committee to inform them.
एंड इफ प्रोजेक्टेड वैकेंट है, अभी डिलाप्लेटेड डिक्लेयर होकर बिल्डिंग तोड़ दिया गया है, तो अभी इसमें हम डीए के बाद में आपने जो बोला कि PAAA करना है, तो ये किस टाइम पे होगा ये कंडीशन में?
अगर डिलेपेड है और आप पहले वेकेट कर देते हैं तो यू टू नेगोशिएट विद द डेवलपर, और डेवलपर अपॉइंटेड है तो.
डेवलपर अपॉइंटेड नहीं है, PMC अपॉइंटेड है.
हाँ, तो देन यू हैव टू वेट फॉर अ डेवलपर टू बी अपॉइंटेड ना.
ओके,
तो अल्टीमेटली उसके बाद आप PAAA करोगे.
एक लास्ट क्वेश्चन है, जो अमाउंट ऑफ सिक्योरिटी आप बता रहे हैं जो बैंक गारंटी है वो कैसे डिसाइड होता है? क्या मतलब
इट डिसाइड ऑन द प्रोजेक्ट कॉस्ट पे.
डेवलपर
प्रोजेक्ट कॉस्ट का अपन परसेंटेज लेते हैं.
वो क्या रहेगा?
ऐसे एकदम फिक्स उसका फॉर्मूला नहीं
क्या
है,
idea?
अपन रफली लेते हैं, रफली.
मतलब समझिए 40 करोड़ प्रोजेक्ट कॉस्ट,
समझो एग्जाम्पल 100 करोड़ है,
हाँ.
तो अपन 20 करोड़ डायरेक्ट नहीं लेते, अपन 5 करोड़ लेते हैं, 10 करोड़ ले सकते हैं, डिपेंडिंग ऑन द फॉर्मूला. उसके बाद
थैंक यू.
हेलो सर
सर मेरी सोसाइटी का ये जो पुरानी सोसाइटी थी उनका 10 ईयर ख़त्म हो गया था दिसंबर में, और उसके बाद 6 महीने के बाद उन्होंने बिल्डर के साथ MOU किया है रीडेवलपमेंट का, और वो नोटराइज है, रजिस्टर्ड नहीं है, तो उसकी वैलिडिटी
टर्म खत्म होने के बाद.
हाँ, उनका 10 ईयर 5 साल
पर जनरल बॉडी का अप्रूवल है क्या?
नहीं, जनरल बॉडी का
अप्रूवल है तो कर सकते हैं,
जनरल बॉडी
अप्रूवल नहीं है तो इलीगल है.
जनरल बॉडी जो है उसमें भी उनका जो अटेंडेंस है वो लेस देन 50 है, कोरम नहीं है, और लेस देन 50% और इवन लेस देन 20 मेंबर्स है, 42 मेंबर्स की सोसाइटी है, तो वो MOU की वैलिडिटी.
अगर आपका टर्म खत्म हो गया है तो आंसर इज नो, दे कैन नॉट एग्जीक्यूट इट unless the general body decides he will allow it for another 6 months, they can execute on our behalf. तो अलग बात है.
बॉडी का भी कोरम
That too is majority. Yes.
ओके, थैंक यू.
सर द फंजिबल FSI जो होता है वो अगर समझो लेट्स से whenever the offer is given, I mean and the fungible FSI, let's say for whatever reasons he is not finding it feasible, I mean the builder is not
Developer, yeah.
the developer is not finding it feasible, and he gives something like, say, instead of that 35% fungible FSI, say somewhere around 30% or maybe 25%, something like that. In that case, the remaining FSI which is there, I mean, which actually should have come to the member by virtue of the way the regulations allows you, can that be kind of be insisted with some?
Yeah. So I understood your question. So if you're not sure about the percentage, example, a PMC is given a feasibility report, उसमें 30% लिखा है पर आपको लग रहा है 40% मिलना चाहिए था. Example, you can take a second opinion from another architect or PMC and arrive at an average or mean of that.
No, I'm asking a different question. I'm saying that ideally the FSI which is coming is free.
Right.
So ideally, if I want to take an advantage see, if I look at in a different way, the society and the developer together are partners in the whole thing in terms of the responsibility also they carry and everything.
And profitability also. Yeah.
And ideally the profitability also. So considering that, so if 35% is a free FSI which is coming, just because it is not probably feasible in terms of the cost of construction which is involved, maybe I'm losing it altogether.
नहीं, पर ऐसा होगा नहीं ना, because PMC पहले आपको रिपोर्ट दे देगा ना. ऐसा सिचुएशन आने नहीं वाला है.
हाँ.
Because ऐसा सिचुएशन आने नहीं वाला है ना, वो पहले से आपका रिपोर्ट आ गया रहेगा ना.
First of all, you understand 30% is carpet or built up. What is he offering you? So built up area 35% he cannot use it as per DCP here. It is very clear. That area will be left in abeyance. So he will not be able to use as per the DCPR. No, you're mixing two things. 35% built-up area is given by BMC free of cost to you for an existing tenant who is 30 years old. No, built-up area. That's the confusion you are making. So if you suppose your area is enclosed by a balcony which will be deducted by 12%, so your eligibility is 22% on carpet, not 35% on carpet. It is 35% on built-up. So you understand that. And if he's giving you 30% on carpet, he's giving you much more than the fungible.
Hello.
In
Sir,
that case, does the offer need to show me the 35% of the built-up at least somewhere?
He will show it on your plan before it's submitting to BMC. Your 35% consumption will be shown on the plan. Before it's
So the answer is like this. There are going to be no surprises after you start the project. Whatever calculation there that happens much before you are vacating the building or you are finalizing even the DA also.
And how detailed should be the offer which is given by the
Detail means it
developer?
should cover all the aspects of the commercial aspects with the member which is required.
Means typically what minimum would be a standard approach to it?
You mean the corpus rent, extra area, brokerage, shifting charges, that is to and fro charges. These are the main 5 parameters.
Okay.
sir.
Sir, good
One
afternoon.
Sorry.
Hello.
Sorry,
Excuse
one
me.
second. The only thing is we're really running short of time. We've
One
got a
last
bunch
simple
of things.
question.
We've got the email address that's mentioned on the stage, which is secretariat@mchi.net. May we request you to kindly make a note of that email address and kindly address all of your problems there.
Ma'am, I have one
last
simple
question. One last question.
Everyone's got the mic in their hand. I
Okay.
think possibly we need to control this a bit better because we've got a few
Okay.
more discussions left.
Okay.
So
My-
one question and
Last
that's about
question,
it,
yeah.
Please.
Sir, thank you for that. And good evening to everybody. Sir, my question is, we are a society on MADA plot. And as per the procedure, after shortlisting a developer, we invited the observer from MADA. And in presence of the appointed observer by sub-register, we concluded for selection of the developer. During that time, we also started the process for due diligence of the developer. And he could not pass the due diligence process. Our report from the chartered accountant on that was negative. Now, can we stop or suspend the further development if he is not satisfied?
Yes, only if majority approve. See,
Yeah.
whether you do the due diligence or no, it
Yeah.
doesn't matter right now. Of course, it matters as far as the project is
Yes,
concerned.
yes.
But as far as this situation is concerned, but the majority of the members have to approve it.
Sir,
Whether
yes.
you select or reject the developer.
That is possible, na? That's
Yes,
why we are
absolutely,
not
sir.
executing any
Absolutely
DA
possible.
vacancies.
Absolutely possible.
Okay, sir. Thank you.
So, thank you very much, everyone.
Thank you so much, Amit. Can we please have a big round of applause for Advocate Ameet? May I request you to kindly be on stage? Please, please, please be on stage. Firstly, thank you so much for taking your time off your busy schedule and joining us back here. As a token of our appreciation, we would like to felicitate you with a memento from Credai MCHI. I may request Mr. Dominic Ramel to kindly join us on stage to do the honors, please. Ladies and gentlemen, can we please have a big round of applause for Advocate Ameet? Thank you so much. Can we have Mr. Sandeep Ishore to kindly join us on stage? All right, ladies and gentlemen, sorry we didn't cut short the session. It was a very long session. In fact, we've exceeded our time back here. If you do have any question requesting all the society members, please take down this email address. Not often do you have authorities disclosing the email addresses just like that, but this is the direct email address to the team at Credai MCHI. Please write at secretariat@mchi.net with all of your questions and your queries will be answered. And obviously, we have Advocate Ameet, who will be around right now. So if you'll have any questions for him, feel free to network with him and speak to him on a one-on-one basis. I think that would be ideal.